Welcome to the Iron Mind Podcast. Join me, Josh Brumley, as we explore the minds of those who forged their paths through legal battles, business triumphs, and creative conquests. In each episode, we sit down with inspiring individuals who sharpened their resolve in the fires of entrepreneurship and law. From lawyers breaking barriers to entrepreneurs overcoming obstacles, we uncover the stories behind their iron wills and innovative minds. Get ready for thought-provoking conversations, practical insights, and actionable advice. This is the Iron Mind Podcast.
When attorneys, I can tell the really experienced attorneys and the inexperienced attorneys that come before me. The experienced ones know the medical records. They know their case. They know the background records. Now, sometimes they weren't aware of something, and I don't really blame the attorney for that. Sometimes it's the client, but they just weren't aware of it. But I can assure you that in every case that's mediated, the defense has probably had a paralegal or a nurse go through the medical records and make a chronology. Or the doctor they hired does that. You know, their CR35 doctor, the defense medical exam doctor. And they have it. Oftentimes the plaintiff does the same, but oftentimes the plaintiff doesn't. And the plaintiff is entering mediation just saying, I'm going to wing it. I'm going to expect the mediator, who I know is a good mediator, to be able to fix it. It can happen. Mistake. I mean, you need to go into the mediation knowing your case, knowing its strengths, knowing its weaknesses, and hopefully giving the mediator arguments he or she can use to take into the other room. Because basically the mediator is the plaintiff's advocate when they go in the defense caucus room, and is the defense advocate when they go in the plaintiff's caucus room. And I had a case where in the middle of the mediation, there was a liability issue. I don't think it was super clear from the beginning, but in the middle of the mediation, the defense attorney said, can we go into a public session? This was in person. It wasn't Zoom, but it could just as easily been Zoom. And they say, we've done some research on why we think they've got problems on liability, and I'd rather explain it to them directly, which as a mediator makes total sense. I mean, for them to convey it to me and hope that I can convey it to their side the same way they conveyed it to me isn't going to happen. That's unrealistic. So I said, well, let me ask the plaintiff and see if they're willing to do that. And they were. And I told the plaintiff, don't feel like you have to respond. They're not expecting that. They just wanted to give you their pitch. And they did, and it was a very effective presentation. I don't really remember now if the plaintiff responded or not, but the case ended up settling, and that, I think that brief public session was very helpful. Another time to do public sessions is if they've never taken your client's deposition, or the adjuster hasn't met your client, and you think your client will make a really good witness, and so you can do a brief public session. So, and usually the way I orchestrate that is I don't want to turn the defense loose in asking questions of the plaintiff, but I say, let me ask questions, and I find out, from the defense what they'd like to know, and I'll ask the questions. But so that's getting ahead of the game, but it's at times where a public session makes sense. But so be prepared, know your case, know the medical records. Mediated a case where the issue is whether the person ever complained about low back within the first several months or year or whatever of the accident, because low back was now an issue. Medical records were this thick. L&I was involved. So, they do tons of records, are not organized. The plaintiff's attorney never went through them. So during the mediation, I took the time, we split up the records to go through it looking for it. We found it. We found an entry, which was all I needed to go, one entry to go to the defense and say, so there is something there. And so we were able to get the case settled. But the plaintiff's attorney should have been aware of that. And it's just, again, if it's a small case, I understand why they wouldn't. And every once in a while you get something like that. The case isn't worth much, but there's a lot of medical records. And you just don't go through it. And that's understandable. It's not cost effective. But when you're asking for lots of money, you need to go through that. So the next tip, and I've touched upon it, you need to advocate for your client, but I think you need to be candid and work with the mediator and be open to the mediator's suggestions. That doesn't mean you have to agree with the mediator. It doesn't mean you have to follow them. You need to be open to them. And in talking to your client, I think in advance of the mediation, you should be telling your client something about the mediator, who he is. Hopefully you've done your homework or you've worked with that mediator before. And to say that mediator may totally agree with everything we're doing. He may have suggestions. He's going to be candid with you. He doesn't have an axe to grind. He'd like to get the case settled. I know, and as you know with me, I don't twist arms. I just lay it out and let you make the decision. It doesn't mean I don't have an opinion. It doesn't mean I might not have thoughts as to what you might do, but I'm not going to twist your client's arm. But so that's important. And it gets back to what I talked about earlier. Somehow you've got to pick a mediator that you have confidence in. And it's easy if you've used the person before, not so easy if you haven't. But it can be done. Third tip, I've had attorneys, not recently, I had one attorney would not let his client talk. This was pre-Zoom, although it would happen with Zoom too. They didn't want the client talking to me. I went, I need to understand from your client. You can tell me all you want, attorney, what your client's going to say and how your client will come across. But as a mediator, the defense is going to ask me, what'd you think of the client? What am I going to tell him? The attorney wouldn't let me talk to him? That's not going to bode well for getting the case settled. If your client talks to me and he's bumbling and I think he's going to make a terrible witness, I'm not going to go to the defense and say he's going to make a terrible witness, but I won't go to the defense and say he'll make a great witness. We'll just kind of skip over that. But the other is I need to create rapport with your client. How do I create rapport if you're putting a tape over his mouth? If I can't talk to your client? And I guess an attorney could say, well, why do you need to create rapport? Well, again, think of the purpose of mediation. It's to negotiate a settlement of the case. It takes give and take. Mediation, settlements in general, involve compromise. Unless you're in the unusual situation of a policy limits case, it involves compromise. It's not necessarily equal compromise, which bothers plaintiffs a lot. We came down this much. They only came up this. Well, that's the way it works. Usually you demand a lot more. But so if you're going to do compromise, then there's got to be some rapport. The client has to be able to develop confidence in me, and particularly in the situations where the attorney tells me on the side, I need you to really burst my client's bubble and expectations. Now, generally, if that's what they want me to do, they would give me every tool available to be able to communicate. And I've had some attorneys tell me that in advance, and then it comes to mediation, and they don't let me do anything, or they fight me at every turn, which is crazy. Zoom mediations in particular, next tip. If there are key documents, have them queued up, ready to screen share. And if you don't know screen share, get familiar with screen share. If you don't know what I'm talking about, talk to the mediator in advance and work with the mediator to figure that out. And highlight things. Don't just stick up a chart note that's all text, but you can highlight it to point those things out. In that case I was telling you about that we ultimately settled for $850,000 that changed attorneys, I used screen share. I took the things from that lengthy 50-page report that the plaintiff's attorney was pointing out to me. I highlighted stuff. I shared it with them. I showed, this is what this means. This is what this means. And if it's an in-person mediation, it just means bring the things with you. I think next tip, consider, again, depending on the value or potential value of the case. Again, I repeat, if it's a small case, you don't do this. But this day and age, civil arbitration is now a $100,000 limit in most counties. And larger cases are being presented in arbitration. But if you think you have a $100,000 case, or you're going to ask the arbitrator for $100,000, as an arbitrator, I'm going to say, well, give me $100,000 worth of evidence. Just don't come and wing it and say that. So I expect if you're going to have I expect almost an IME from the plaintiff, a forensic report. I want it to address the defense medical exam. Spend the money, spend a few $1,000s to do that. Don't give me declarations with conclusory opinions that are just enough to get by a summary judgment or something. Your expert needs to be persuasive. Persuade me so I can persuade the other side. But give serious thought with Zoom to having a key witness, key expert come in person, on Zoom. Say, listen, we've got a mediation from 9:30 to 1:30 or 9:30 to 5:30 if it's an all day, and find out a time that he or she will be available to talk on Zoom and do it. It could be just with the mediator, but if it goes well, as a mediator, I would want to invite that communication to be with the defense as well. But you play that one by ear as to how it goes. So give thought to that. There's and that would be better than a report. Well, it's better than a report if the defense is listening, if they're participating. If not, well, you need a report.
And the doctor would have to go through all those records to be able to articulate things anyway, so you're probably paying the money you would pay for the report anyway.
In many instances, they've done a report. But so you don't need the doctor for a lengthy thing. It may be the doctor's done his report and the defense has done a defense medical, and what you want the doctor to comment on is the opinions that the defense doctor did. Because that may not be in his report, but then he can add that and supplement it. So you have to think about, is that worth it? The larger the case, the more it's worth it. And bear this in mind. I don't have exact statistics. This is more anecdotal. But my belief and understanding is at the end of the day, about 95% of personal injury cases settle without going to trial. They may settle on the courthouse steps, but they settle. So if 95% or even 90% are settling, why would you not invest the time and money into preparing for mediation? I've had people say, well, I want to keep that out. And I don't want that piece of information out because I want to hold that back for trial. And I go, that's your call. It's a strategy call. But if 90 to 95% settle, if you hold it back, you're not getting the advantage of that as influencing the value of your case. So is it really that critical that you don't tell them? And particularly if discovery cutoff has come and gone. But there can be some circumstances where the plaintiff just feels or the defense feels that's a real smoking gun and I want to keep it to myself. But this goes both ways. But you have to give some thought to that as to put your efforts into settling. And a few years ago, I haven't seen it so much lately, on the WSAJ listservs, people said, don't even try to settle your case. Just try it. Now, I think that's a great way for young attorneys to get experience. And if you don't try the cases, you're not going to get the experience. If you don't try the cases, you're not going to get a reputation with the defense firms and the insurance companies that you'll take the case to trial. So there is a lot of value to that. But it's not always in your client's best interest to do that. And as you know, we have to always focus on what's in our client's best interest. And even though maybe I'd like to go to trial on it, is that really what my client wants? Is that going to be the benefit? Is my client a gambler? Can the client take the risk of going from a low verdict to a higher verdict? Those are all important questions to ask. But nowadays, I don't see that so much. And maybe it's the quality of the mediators has improved to a point where people are getting good settlements with mediation. I mean, I don't really have an answer for that.
Well, and the arbitration limits are much higher now, too. So that changes the evaluation of what's going to go to trial and what doesn't.
This next tip I more or less talked about. It's like give the mediator arguments he can use on the other side. I've mediated cases when I was an advocate where I had co-counsel that was real experienced. And they always had, every time the mediator came into the room, they had more arguments to give them. We'll here, we're going to come down to this, and here, give them this argument, give them that. Now, I have mixed feelings about that. As a mediator, I'd like to know everything. I don't mind that we dole it out, if that's what the plaintiff wants me to do. But I'd rather have the flexibility to use those arguments that I think are best to use. Because sometimes someone may give me an argument saying, talk about this, and they're holding back this, but it would work better if that were combined with this, as opposed to, okay, next time, because the person will say, well, we've already argued that. I don't need to deal with that again. Next tip, no surprises at mediation. And what I really mean by that, I can't tell you historically the number of times we've come to mediation and the plaintiff's never made a demand. I'm going, well, do you know how this works? The defense attorney takes the demand to the insurance adjuster. The insurance adjuster has to evaluate it. The insurance adjuster writes up a recommendation that goes to his superiors. They round table and they give authority. Takes time. If they don't even know what you're demanding until they come into the mediation, then you're wasting time. I mean, they can't possibly address that. Or they've made a demand, but they haven't given them the details on the wage loss. Or there's still, they have $50,000 in medical bills, but there's another $50,000 that they present for the first time at mediation. Now, there are times when that can't be avoided because you didn't have them, especially this day and age. It takes so long to get medical records. But as a plaintiff attorney, don't think the defense is going to consider that additional $50,000 in medical bills that you're just giving them for the first time. They won't. So will they maybe increase their offer a little bit to offset it? Yeah, but it won't be a like for like by any means. So surprises don't work. And I would highly recommend, in fact, when I send out my initial engagement letter, I tell them, make your settlement demand well before the mediation. Give the insurance company an opportunity to assess it. And what happens a lot is sometimes people just make a policy limits demand. But at the time they make the demand, it was pre-lawsuit. They don't even know what the policy limits were. And does that mean that the defense and the insurance company can't kind of guess what they're demanding based on how it's presented? No, they probably can. But then you're putting control on the defense. They're saying, well, I assume he wants $100,000 when really you want $200,000. Well, they've just evaluated their whole case based on $100,000. You're not going to get them to go to $200,000. So no surprises.
It's not like TV show. No. You want it lined up, teed up, perfectly ready for trial before you get to mediation. No surprises.
That would be my biggest tip. Yes. Next, if you have subrogated carriers, and in other words, as a young attorney, if your client has had his own insurance, health insurance or PIP, pay bills, and they have a lien,
it's not like TV show.
Have talked to them in advance of the mediation. Or L&I is involved. It's a combination workers' comp PI case. With L&I, you have to have someone from the Department of Labor and Industries available at the mediation, because basically they have to, if you're asking them to accept a discount, they have to approve the settlement. So you don't necessarily have to have the agreements all made in advance, but you need to have touched base. You need to have given them information. And when it comes to a subrogated carrier, I always told my clients, I wear two hats in these cases. Hat one is the first hat is the one I wear when I'm negotiating with the defendant. The second hat is the one I wear when I negotiate with my first-party carriers, my subrogated carriers. That second hat is going to look an awful lot like I'm the defense attorney. And in fact, if the defense attorney has a report from a doctor that really hurts us, I give that report to the other side. And I tell, or not to the other side, but to my subrogated carriers, I say, I'm worried about this. So you need to have given that so they can give it some thought.
And just to take that idea to the next reasonable conclusion, by giving a defense IME, for example, to the PIP adjuster or to the health insurance
or to L&I,
you're saying, these are things I'm scared about. can you reduce what your lien is so that we can get this case resolved and you'll get some money rather than us take it to trial and then lose everything?
Yeah, that's essentially what you do. But you should really go over that with the mediator as to how to do it. Sometimes it's best coming from the mediator.
The mediator would contact the adjuster for PIP?
It just depends. Well, first of all, with PIP, usually it comes from the plaintiff's attorney. Mm-hmm. But sometimes the mediator has to jump in. And so if they're available by phone, the mediator can contact them during the mediation.
Gotcha, I see.
And that can be very important. There are cases where you can get the subrogated carrier to drop thousands and thousands of dollars off their lien, based on those things. And particularly if there's an issue over liability, where there's a concern it could be a defense verdict or significant comparative negligence, because the case law is such that if the subrogated carrier is governed by Washington state law as opposed to federal law, ERISA, if there's any discount for liability whatsoever, if any comparative negligence, the subrogated interest is zero, because your client will not be made whole. So know the law on that. Be up on that for dealing with your subrogated carrier. Now, with L&I, there's a formula, statutory formula that's followed. But if it's a case where it looks like either because the policy limits aren't high enough, or there are issues about the nature of the treatment, the amount of the treatment, whether it's related. What a mediator frequently does, if it works to the client's advantage, the plaintiff's advantage, is suggest a settlement where the department gets a third, the client gets a third, the attorney gets a third. That's not an unusual compromise that the department is used to hearing, and in the right case more or less agrees to it. The tougher element in those settlements is getting I think it's called a set aside. I always forget the name, but a lot of times L&I will say, okay, this is how we'll deal with this, but we're going to assume that if this person needs continuing treatment or continuing time loss, the next $50,000 worth of treatment or time loss we don't pay out on. Well, now if your case is closed and the plaintiff is never going to reopen the claim, you don't care so much about that. But if it's not, that's a significant area of negotiation, and there's creative things that can be done. Then second to last, I can't tell you the number of times I've been in a mediation where I go into the plaintiff's room and the plaintiff's attorney says that defense attorney is a horse's petard. He's terrible in discovery, he never gives us anything, you can't trust him, on and on and on and on. Then I go in the defense room and the defense attorney says, I can't tell you how much of an
a-hole
that plaintiff is. He's always late with this, he's late with that, you can't trust him. And it's like, well, which is it? To myself. And I like the plaintiff's attorney and I like the defense attorney. They both seem honorable and straightforward. So I don't know. But my attitude, and this is not a tip just for what to do at mediation time, but it's how you handle the case from the beginning. My firm belief is you always be polite and professional. You always turn the other cheek. Now, I know a lot of attorneys will disagree with me vehemently on that. You got to take a stand. Well, and I say always, generally. Maybe I should use generally. There can be exceptions. But when it gets down to mediation, if you've got an attorney that the defense hates, the insurance company has been dissed by this person and they don't like him, and then you have an attorney that they really like, in a close case, are they going to fight to give a few more $1,000s to the attorney they hate or to the attorney they like? And maybe they won't give it to anyone. But if they like you, they're going to go the extra mile to see if they can get that case settled. If they don't like you, if they don't trust you, if they think that you're the worst of what the bar represents, they'll say, try the case. We don't care. Yeah. And so it can't hurt you to be polite and professional. You can't take things personally. You can, but it's a mistake to take things personally. I had a case, and this is, I actually co-tried this with this very senior attorney that I shared office space with. And this is the most mellow man you would ever meet. But for whatever the reason, the defense attorney pushed this guy's buttons. And so in motions, and there are a lot of motions in this case, he'd always attack us. It would always be like we intentionally did something wrong. That's not, I would never respond that way. I just respond more neutrally about things. But that really bugged my co-counsel. And we got to trial, my co-counsel just couldn't see straight, basically. And the defense attorney in trial was Mr. Polite. So the jury didn't know anything about what kind of a jack-off he was. And it hurt us. I mean, we were a prevailing party, but we didn't get the kind of money we wanted to get. And my client, my co-counsel kind of lost it at trial. So you can't take things personally. You just have to be professional at all times. It works to your client's best point. Final tip, be willing to walk away. That may be the most important. Come to a mediation. You can come hopeful the case will settle. And you can listen to the mediator and be flexible and be willing to manipulate, the way you see the case. But you can't come in there and say, I'm going to settle no matter what, with one exception. If it just isn't getting to what you and your client talked about, even taking into account whatever the mediator's input, if it doesn't get to that, don't get mad, don't get frustrated, which happens a lot. Walk away. You don't have to slam your books down and walk away, but just say, no, well, I guess we'll just have to try this case. Because some cases are meant to be tried. Some cases, to get the amount of money you want, it's going to have to be a jury that tells you that that's what the case is worth. That's just the way it is. And treat it as an opportunity. Great, they're giving me an opportunity to get trial experience. And that's the way you have to look at it. And if the one exception I talked about is sometimes you have clients that just won't go to trial. Or your client's going to be awful. But if you know the client's being awful, then you shouldn't be offended by that kind of an offer.
They probably deposed your client at that point and know your client's going to be awful.
Which is, I know, kind of leads to something else, but it's related to this. You really need to try and step out of your shoes when you assess your client. Really any witness, but particularly your client. How's this person going to appear before a jury in a jury trial or a judge in a bench trial? I had a client, and again, I use the same co-counsel, this old, more experienced attorney. The client came in and met with me, and unbeknownst to me, he then met with the other attorney as well, because we weren't partners. I didn't like this guy at first. He had ADD. He was off the wall. I thought he had a good case, but I just wasn't crazy about him. And then I found out that he met with my cohort, and I talked to him. He felt the same way. We said, well, let's bring him in and meet him together. Well, as we got to know him and understand him, we started to like him. We said, oh, no, okay, now we see what the issues are. The problem is the jury only saw him once. Their first impression of him was what our first impression was. Oh, no. And so it was a bad result. So the lesson there is also don't ignore your instinct. If you've met the person, you don't care for him, why do you want that headache?
Right. Be willing to say no to clients.
Yeah.
Which is tough for new practitioners because you don't know when your next case is going to come through the doors, and you got payroll to make and lights to keep on, and so you
and then
might
what happens if that client, then you take them on, they become a troublemaker.
Right.
At some point you have to make hard decisions. There's been clients that don't respect your staff.
Oh yeah.
And then they talk to you, they're just apple pie and ice cream. But but I have no reason to not believe my staff when they tell me he just cusses us out, he does this, he does that. And at some point it's just life's too short. You just can't handle that case.
No. Those are the people that cause problems throughout the process and then cause problems after the case is closed anyway. You just don't need that headache.
Yeah, that's a real problem too. The ones that cause trouble after the case.
Yeah. Well, so for these 10 Steve Toole tips, are these tips that you think cut the exact same way at arbitration, or are they different for mediation than arbitration?
Very similar at arbitration. In other words, you got to know your case thoroughly. You have to be prepared at arbitration hearing, particularly with lots of, even if it's mandatory, if you're looking for the high amount, or if it's UIM and there's higher limits, you need to give serious thought to having your doctor testify via Zoom. In fact, I would think that's way more important at arbitration.
Yeah.
Where the arbitrator is making the decision than it is at mediation. And I'll give an example. When you have the let's just say it's a doctor. When you have the doctor testify.
And are we talking treating doctor or are we talking expert?
Either one.
Okay.
If it's a key treating doctor, or if you went and got a forensic doctor to review all the medical records, just depends on the case. If they testify, I get to see them, judge, how, for myself, the credibility. I get to see them cross-examined, which I think is important. And I get to ask questions if I feel there's some key things that weren't covered, by either attorney. And that's important for me in making decisions. If all I have is a report, even if it's a 30, 40-page report, there may be things I think are important that aren't covered in the report. They may have given an opinion that I want to really explore. Doctor, I understand what your opinion is, but tell me why. Why can you say that on a more probable than not basis? So I had a case, UIM arbitration. It must have been UIM because the limits weren't the issue. I don't remember. The defense had a known CR35 doctor testify, orthopedic surgeon. I had his report. His report says what they always say. And he did pretty good in his testimony. He's supported. He's smooth. The guy's smooth. But he was really doing a lot. Well, the guy never followed up with his doctor. He didn't do this. The doctor doesn't say this. The doctor doesn't say that. Well, if you read the records, it's the physical therapist that had the contact with him. The plaintiff called the physical therapist to testify. I don't remember now if it was in person or Zoom, quite frankly. Probably in person. Answered all those questions. And I could judge the credibility. There's physical therapists that are kind of flaky, and there's physical therapists that have been doing it for 30 years and they know what they're talking about. This was one of the latter. And when you went through his CV, his curriculum vitae, he had done some big time stuff. He had testified a lot. So he was very impressive, even though he was only a physical therapist. But far more impactful than if I just had a report from him. Far more. So I think people forget in this day and age, particularly of Zoom, but arbitrations in general, they forget about the value of having someone come in and testify live. I did a case 3 weeks ago. Liability was an issue. And this was an expert. The two plaintiffs, passenger and driver, were both deposed. The defendant was deposed. The plaintiffs testified via Zoom. The defendant did not. And it was really a black and white thing. It either happened the way the plaintiff said or it happened the way the defense said. There were circumstantial elements on each party's side that supported their statements. But it wasn't like they went both ways. It was tough. It was a tough case. And I ultimately ruled for the plaintiff because there were some credibility issues that the deposition didn't cover. For instance, the guy was driving a commercial truck and the plaintiff had a photograph that was submitted of the defendant with his door open as though he was getting out of his truck, seemingly holding a cell phone in his hand. And it was like the distance was you to me. There's no way that the driver was looking right at the camera. It was a cell phone camera. Yet the driver in his deposition said he'd never seen the plaintiff before. Nobody, he never met him, et cetera. And I'm going,
how do you get this photo of you
how
then?
did he get this photo? It just didn't make sense to me. And the plaintiff said the defendant told him he was on the cell phone calling 911. He did have a cell phone in his hand. It seemed to be a cell phone. The photo wasn't that great. I couldn't be certain. But then there was an issue where on the defense side, there was a building with a white wall or a gray wall, and the truck after the impact was backing out and hit this guy in a gas station parking lot. Said he pulled back up into the spot. And so the photo was taken at such an angle that he'd say, well, that's not a gray wall. It looks like there's a car that you see through the windshield. To myself, that's a valid point. But what I realized in the testimony, nobody asked, and therefore there was no answer as to how far into the parking stall he pulled. Did he just pull a little bit in, or did he pull all the way up against the wheel stop? And if he did, if it was all the way up against the wheel stop, then you'd think you'd see the side of the building. But the angle was such that if he was only back a few feet, it was such you would have seen the car. So I just went, if they had called him to testify, it may have been a different story, but they didn't. And that's that. So I ruled in favor of the plaintiff.
So, and I'm sorry for interrupting, but that's a really great point. And I think a lot of times the benefit for plaintiffs in arbitration is not having to call these witnesses and having to electing to have them testify via declaration. And what you're saying, it is, as an arbitrator, it is so much more powerful to have them give live testimony than it is to testify via declaration.
Yes and no. If it's a controversial issue, yes. Sometimes, you're calling lay witnesses and say, well, this is what I observe. I've known this person for 20 years.
Oh, sure.
No, a declaration's fine in that regard.
I mean, like the treating doctors, for example. A chiro.
And again, it depends on the value of the claim. If you've got a case with 6 months of chiropractic care, $9,000 in medical bills, probably having someone testify live is meaningless. If you have the doctor saying, when I discharged him, he had not reached maximum medical improvement, he's going to need this kind of treatment for X period of time. And you're making a large future claim for medical specials, then it's probably important to have that doctor testify, or at least you talk to him and see if he's persuaded you. You can avoid a lot of expense if, as an attorney, you talk to the person, you ask the tough questions, you assess for yourself, can I sell this? For instance, the number of times I see, let's say accident occurred in 2018, lawsuits filed 2020. The last treatment was 2020. It's now 2023. In the last treatment, the doctor says, you're going to need about $1,500 worth of therapy or this or that every year for the next 10 years. And you see the person has not had any treatment since then. Well, that's a credibility issue. Now, in reality, it may be, I can't afford it.
Right.
But it doesn't matter. The doctor needs to explain that. Now, in that case, if it were me, I probably just wouldn't go for that future care.
Gotcha.
And you don't, and then you don't need them. But if you've got something, particularly the doctor does his thing, gives you his report, his declaration. It's good declaration, but then the defense comes up with a CR-35 report and addresses certain things. I will tell you, either have your doctor do an addendum to address those, or as an arbitrator, I'd rather hear him testify. Because probably the defense doctor will not be called to testify. And it's going to be more impactful for the plaintiff if the doctor can do a good job rebutting that. And frequently it's like, no. Is the defense doctor ever right? Could that be? Sure. But we're talking what's more probable than not. And that is a maybe. He gives his explanation and it makes sense. And again, if you're asking for enough money, then it's worth the expense. If you're not, then it's not.
Right. You had also mentioned, I think this was a really cool kind of anecdote, but the attorney that worked for O.J. Simpson that you met, do you want to talk about that?
Sure. Johnny Cochran, who's now deceased. He was a well-known defense criminal attorney, as well, representing O.J. Simpson, and it was a great plaintiff's personal injury attorney. And we had, when I was president, we had him up here for some seminar. I don't remember the specifics. So we had a big luncheon, and boy, it was a big turnout. People wanted. This was right after the O.J. result, if I'm not mistaken, or soon after, and people wanted to hear him. But he was asked what he feels is really critical in getting good results in personal injury trials. And he said, in any trial, and he says the 3 P's, triple P: preparation, preparation, preparation. And he couldn't emphasize that more, that is just critical. You need to out-prepare the other side. You need to anticipate everything. You need to be ready for anything that takes place. And it's hard to argue with that.
Great advice. All right, and in closing, I ask all my guests, how do you define being an iron mind attorney?
Well, first of all, we had to look up the definition because I wasn't familiar with that. And my understanding is it's a mind that is resilient to fear, anxiety, and indecision. I think the first thing to understand, everyone has fear, anxiety, and indecision. How many times do you hear an actor on a talk show talk about the butterflies they go through, even though it may be the 1,000th performance that they've done on Broadway? That's life. Fear, we're afraid of failure, we're afraid of losing, we're afraid of making a mistake, whatever it may be, and that leads to anxiety. And then the two combined lead to indecision. So what do you do when you have fear and anxiety? You do nothing. And I have gone through trainings in my life that have taught me there's reasons and there's results. And I take that approach that we have to look for results in cases, resolutions, solutions. And if you let fear get in the way, you're not going to get results. If you let anxiety get in the way, you're not going to get results. But we all have indecision. And so you have to do, and I find by being this iron mind attorney, not that I still have indecision, I still procrastinate, but I've adopted in short ways. I look at my desk and there's piles of to do, and this always gets pushed aside. This I do right away. This gets pushed aside. And as soon as I recognize, I keep pushing that aside. And what I do is I move it to the front. I say, obviously I'm resisting that for a reason, but I've just developed the ability to just go, I've got to deal with that. That's all there is to it. And that's that iron mind, that strong mind. Don't procrastinate. Fear's still there. It's always going to be there. Anxiety may still be there, but I will tell you that once you pull it in and do it, you feel great. I mean, you go, why did I put that off for as long as I put that off? And so I think that to me, that iron mind is just work through it, just get it done. Put all the fear, all the anxiety out of your mind. Think about results. Go, I have to get results. How am I going to get results? I've got to work on this thing that I'm resisting. And just go do it. How many times have you talked to somebody? Maybe you're giving them a proposal. And they go, I need to think about that. How long do you need to think about it? That would be my response. 2 weeks. Okay. I'm curious. Does that mean that for the next 2 weeks, you're going to do nothing but think about that? Or does that mean you're going to go 1 day less than 2 weeks doing whatever you do, and then when that deadline comes up, you'll think about it? And they usually chuckle. And my experience is, make a decision. Now, it's one thing if it's something you need data and you don't have the data. But quite frankly, most people use that as an excuse. Reasons or results? Reason, I don't have enough data. Yeah, you do. On some level, just make a decision. And I think an iron-minded attorney is better at making those decisions and just acknowledging fear, acknowledging anxiety, and saying the resulting indecision is not okay. Because it's going to be there tomorrow, it's going to be there next week, it's going to be there next month. It's not going to go away. And just work through it.
That's great. That's a great definition. Do you think that this same indecision, fear, anxiety that leads to indecision is a big part of why young attorneys don't try cases?
Oh, it was for me. Oh, gosh, yes. That and money.
Yeah.
Not having the money. But then I go to, and I mentioned this to you, if you're a young attorney and you've got a case that's a good value, associate a more senior attorney. You're going to take less of a fee, but you're going to learn. And don't just associate them, turn the file over to them, and just wait to get a third of the result or whatever, a third of his fee. Work the case with him. Attend the depositions, or whether it's Zoom or otherwise, and learn. Can I do the research on that? And work as a team. We'll develop a plan how you can work things together. That's how you learn, and that's how you can be a sole practitioner and get experience and develop as a trial attorney. Whereas if you're part of a 20-person firm, you'd have the people all there around you where you could do that. But you don't have that luxury. So, sure, young attorneys, fear is... I'm impressed by young attorneys that mediate with me that are just saying, I'm prepared for trial. When they come to mediation, I know if they're prepared for trial. I can see. And those who are prepared for trial, it's like the fear factor isn't as big because they've prepared. And they're still, it's an unknown as to what the result will be, but they've done their homework, they've prepared, and it's not as fearful as it would otherwise be. And anxiety, I guess there's two ways to look at it. It's like change. People fear change. You lose a job. Well, another way to look at change is it's an opportunity. Maybe on some level that job wasn't right for me. Now I have an opportunity to get a new job. Create a better situation for myself. And so it's that anxiety kind of gets in the way, but if you look at it as, well, it's not anxiety, it's an opportunity.
Change your mindset.
Yes, a scary opportunity, but an opportunity.
Yeah. Well, I think that's a great outlook to have. I think that a lot of these young attorneys or experienced attorneys who maybe have never dipped their toes into personal injury and have been contemplating it, listening to this, might take this advice and run with it. And I think the best tidbit that we could take away from this, if you don't know what you're doing with personal injury, you can always associate with an attorney who does. And you can still learn and keep your client's interests protected. You're not hurting people from rolling the dice and losing on a motion for summary judgment and then having a malpractice claim. You just need people to be involved, and a big part of that is having a network. And so thank you, Steve, for being a part of this this episode. Thank you for your candor with what young attorneys can learn from you and from your tips on your website. Please check out Steve's website, and thank you all for listening.
Thank you. My pleasure.
Hi, everyone. Thanks for tuning into the Iron Mind podcast. Please remember to like, review, and subscribe, and thanks for listening.